May 4, 2023 Unit 12 Adjacent Property Rights, Abatement, Accretion. Affirmative Easement, Avulsion. Doctrine of Agreed Boundaries. Dominant Tenement, Easement. Easement by estoppels. Easement by necessity. Easement by prescription. Easement in gross, encroachment. Implied easement. Lateral support, license. Literal rights, merger. Negative easement, nuisance, reliction. Right of correlative use. Right of prior appropriation. Riparian rights. Servient tenement. Spite fence. Subjacent support, trespass, abatement, the act of reducing or eliminating a nuisance, such as a hazardous condition or a violation of zoning or building codes, on a property. Abatement can be carried out by the property owner, government agencies, or other parties authorized by law. Accretion, the gradual buildup of land or soil due to natural processes, such as the deposit of sediment by a river or the accumulation of volcanic ash. Accretion can lead to changes in property boundaries and ownership, and can give rise to legal disputes between neighboring property owners. Affirmative easement, a legal right that allows the holder of the easement to use the property of another person for a specific purpose, such as access to a road or the installation of utilities. An affirmative easement is a type of easement that grants the holder the right to do something on the property of another. Avulsion, the sudden and violent removal of land or soil from one property and its deposition onto another property, such as during a landslide or flood. Avulsion can lead to changes in property boundaries and ownership, and can give rise to legal disputes between neighboring property owners. Doctrine of Agreed Boundaries, a legal principle that allows neighboring property owners to agree to the location of a property boundary, even if it differs from the boundary established by a survey or legal description. The doctrine of agreed boundaries can be used to resolve disputes between neighboring property owners or to avoid costly and time-consuming legal proceedings. Dominant tenement, a property that benefits from an easement or other legal right, such as access to a road or a view easement. The property that is subject to the easement is known as the servient tenement. The dominant tenement usually has the right to enforce the easement against the servient tenement and to maintain the easement in a condition that allows for its use. Easement, a legal right that allows a person to use the property of another for a specific purpose, such as access to a road or the installation of utilities. An easement is a non-possessory interest in land and can be created by agreement, implication, necessity, or prescription. Easement by estoppel, a type of easement that arises when the owner of a property leads another person to reasonably believe that they have the right to use the property, and that person relies on that belief to their detriment. The easement by estoppel is created by the conduct of the property owner, rather than by a formal agreement or legal action. Easement by necessity, a type of easement that arises when a landlocked property owner requires access to their property over a neighboring property. The easement by necessity is created by the need for access to the property, rather than by a formal agreement or legal action. Easement by prescription, a type of easement that arises when a person uses another person's property without permission for a certain period of time, usually many years. The easement by prescription is created by the continuous and open use of the property, without the permission of the owner, for a period of time prescribed by law. Easement in gross, a type of easement that benefits a person or entity rather than a specific property. An easement in gross does not require the existence of a dominant tenement, and the easement holder may not own any property adjacent to the servient tenement. Encroachment, the unauthorized intrusion of a structure or other improvement onto the property of another, usually due to a mistake or error in property boundaries or surveying. Encroachments can give rise to legal disputes between neighboring property owners and may require the removal or alteration of the offending structure. Implied easement, a type of easement that arises by implication or necessity, rather than by express agreement or legal action. An implied easement is created when the circumstances surrounding the ownership and use of the property suggest that an easement was intended, even though it was not explicitly granted or reserved. Lateral support, the support provided by soil or other material adjacent to a property that prevents the collapse or failure of a building or other improvement. Property owners have a duty to provide lateral support to neighboring properties, and can be held liable for damages if their excavation or construction activities cause the loss of lateral support. License, a temporary and revocable permission granted by the owner of a property that allows another person to use the property for a specific purpose, such as parking a car or holding an event. A license does not create an interest in land and can be terminated at any time by the property owner. Literal rights: the rights of a property owner whose property borders a body of water, such as a lake or ocean. Literal rights include the right to access and use the water, as well as the right to construct a dock or other structure for boating or other recreational activities. Merger: the combining of two or more properties into a single property, usually as a result of a purchase or transfer of ownership. When properties merge, any easements or other interests in the merged properties may be extinguished or modified. Negative easement: a type of easement that prohibits the owner of a property from doing something that would otherwise be allowed, such as building a structure that blocks the view of a neighboring property. A negative easement is a restrictive covenant that limits the use of the property and benefits a neighboring property or the public. Nuisance: an activity, condition, or use of property that interferes with the use and enjoyment of neighboring properties, or that is offensive or injurious to the public. Nuisances can be caused by noise, odors, pollution, or other factors, and can give rise to legal claims for damages or injunctive relief. Reliction: the gradual and imperceptible recession of water from a body of water, which exposes land that was previously submerged. The owner of the newly exposed land may become the owner of the land, subject to any public rights in the navigable waters. Right of correlative use: a principle of water law that grants each owner of a groundwater basin the right to share in the reasonable and beneficial use of the basin. The right of correlative use limits the amount of groundwater that can be withdrawn by each owner to ensure that the supply is not depleted. Right of prior appropriation: a principle of water law that grants the first person to divert and use water from a water source the right to continue using the water, even if others have competing claims. The right of prior appropriation is used in many Western states to allocate scarce water resources. Riparian rights: the rights of a property owner whose property borders a natural watercourse, such as a river or stream. Riparian rights include the right to access and use the water, as well as the right to maintain the natural flow of the water and protect the ecological balance of the watercourse. Servient tenement: the property that is subject to an easement, and that is required to allow the owner of the dominant tenement to use the property for a specific purpose. The servient tenement is burdened by the easement and cannot interfere with the exercise of the easement by the owner of the dominant tenement. Spite fence: a high fence or wall that is built for the sole purpose of annoying or injuring a neighbor, rather than for any legitimate use or purpose. Spite fences are illegal in many jurisdictions, and can give rise to legal claims for damages or injunctive relief. Subjacent support: the support provided by the underlying land or soil to a building or other structure. Property owners have a duty to provide subjacent support to their own buildings, and can be held liable for damages if their excavation or construction activities cause the loss of subjacent support to neighboring properties. Trespass: an unauthorized entry onto or use of another person's property. Trespass can occur in many different forms, such as physically entering onto the property, placing objects on the property, or interfering with the use or enjoyment of the property. Trespass can give rise to legal claims for damages or injunctive relief. Boundary disputes: when exact property boundaries are uncertain or in dispute, the parties involved can mutually agree to set a fixed line that is clear to both parties. According to the doctrine of agreed boundaries, agreed on boundaries are binding on successors in interest after the boundary has been accepted by the parties for 5 years. Spite fences: fences more than 10 feet high that are erected or maintained for the purpose of annoying an adjoining owner are a private nuisance and can be abated. Encroachment: an encroachment is an intrusion into, under, or over the land of another. An action to remove a permanent trespass, encroachment, such as a building, must be taken within 3 years of the encroachment, or the encroachment will be allowed to remain. A nuisance is normally a non-physical invasion that affects the use or enjoyment of others. It could be smell, dust, light, noise, vibrations, radio interference, dangerous activity, indecent acts, or hours of operation. Action involving a nuisance could be money damages, injunction, or abatement, removal, of the nuisance. Water-related terms following are important water-related legal concepts. A riparian rights are rights of owners to the reasonable use of water flowing adjacent to, under, or through the property, rivers or streams. Riparian rights are held in common with other riparian owners, even though an owner might never use them. A littoral rights are rights of owners of property bordering lakes, seas, or oceans, non-flowing water, to a reasonable use of the water. The right of correlative use holds that an owner does not have absolute use of the groundwater not in a defined watercourse under the owner's property. When water is scarce, an owner must share the water table with other owners. The use of underground percolating water in relation to the other owners must be reasonable according to the right of correlative use. The right of prior appropriation is a concept in several Western states that whoever takes water first gets a priority right to future use. While California courts have followed this concept, it has not been followed by the federal courts. One who does not own riparian rights can get rights of prior appropriation through either an easement by grant or an easement by prescription, discussed later in the unit. An easement by prescription would require the open, notorious, and hostile taking of water under some claim of right for 5 years without interruption. Accretion is the gradual and imperceptible buildup of soil by natural causes, such as by action of wind or water. The addition to the land, known as alluvion, belongs to the property to which it is joined. Title is acquired by accession. Avulsion is the sudden loss of land by action of water, such as a change in a river's course. A property owner has 1 year to reclaim the property. The river could be diverted back to its original course. A reliction is a right, holding that when a lake, a sea, or a river permanently recedes, the adjoining waterfront property owners can take title to the adjacent land created by the withdrawal of the water. An easement is a legal interest in the land of another that entitles the owner of the easement to a limited use or enjoyment in the land of another. It is a non-possessory interest of one who does not control possession as an owner or a tenant. Most residential properties are subject to easements, with utility easements being the most common. Servient tenement: the land being used by another is in servitude, or serves the needs of another. The land being used, therefore, is known as the servient tenement. Because the use by another necessarily places restrictions on an owner's use, a servient tenement is an encumbrance on the land. If the location of an easement is not specified, the servient tenement holder can reasonably designate the easement area. Dominant tenement: normally, an easement benefits other land. For example, ownership of a parcel of land could carry with it the right to cross another parcel. The land being benefited by the easement dominates the servient tenement and is known as the dominant tenement. Because a dominant tenement carries benefits with it in the use of the land of another, the easement is considered an appurtenance to the land. Easement rights run with the land, so transfer of title also transfers the rights and/or obligations. The rights of the dominant tenement cannot be separated or conveyed without the land. The dominant tenement need not be adjacent to the servient tenement. Easement in gross: an easement in gross is an easement right that is not joined to any dominant tenement. It is considered personal in nature. Examples of easements in gross are a right to erect a sign on the land of another and a utility company's right to run lines over a property. Easement by prescription: an easement by prescription is an easement obtained by use. For the user to obtain the easement, the use must be open, notorious, hostile, under some claim of right, and continuous for 5 years. Courts hold that a claim of right does not require a belief or claim that the use is legally justified. It merely means that the property was used without the permission of the owner. California courts will in some instances create an easement by necessity when an easement is required to allow reasonable use of a property. Easement by eminent domain: easements can be obtained by condemnation for any public purpose. This right has been given to utilities for rights of way. The landowner is entitled to be compensated for any loss in value caused by the taking of the easement. An easement by estoppel can be created when an owner, by words or acts, causes another party to act to the other party's detriment. Unlike an easement, a license is not an interest in land, it is a permissive use. What would otherwise be a wrongful trespass would be permissible with a license. Unauthorized use or trespass does not create a license. A license always requires permission and is revocable. Unit Quiz 1, which correctly matches the boundary with its boundary line? A. Road, center of the road. B. Non-navigable river, center of the river. C. Navigable river, average low water mark. D. All of these are correctly matched. Answer D. All of these are correctly matched. 2. When a tree trunk is on the boundary line, A. Both owners must agree to its removal. B. It belongs to both owners. C. Both owners can trim branches over their own property. D. All of these are correct. Answer D. All of these are correct. 3. An action for the removal of a permanent encroachment must be commenced within A. 3 years of the encroachment. B. 4 years of the encroachment. C. 10 years of the encroachment. D. A reasonable period, answer A. 3 years of the encroachment. 4. A non-physical invasion of the property of another would likely be A. An encroachment. B. A trespass. C. A nuisance. D. An easement, answer C. A nuisance. 5. What is true regarding nuisances? A. There is a 3-year statute of limitations on a private nuisance. B. A public nuisance cannot be abated by the action of a private citizen. C. Nuisances that are not private nuisances are considered public nuisances. D. All of these are true, answer D. All of these are true. 6. A dispute between riparian rights holders would likely be heard by the A. Federal District Court. B. Local water agency. C. Water Resources Control Board. D. None of these, answer C. Water Resources Control Board. 7. After an owner developed his property, water runoff from it damaged the lower property. Which statement about liability for this damage is true? A. The upper landowner is strictly liable. B. The upper landowner is liable for only the percentage of damage based on the percentage of increase in runoff. C. If the development was reasonable use of the land with reasonable care, the upper landowner is not liable. D. None of these is true, answer C. If the development was reasonable use of the land with reasonable care, the upper landowner is not liable. 8. Riparian rights can best be described as A. The absolute right to adjacent water. B. Reasonable use of flowing water. C. Reasonable use of non-adjacent water. D. Reasonable use of non-flowing water, answer B. Reasonable use of flowing water. 9. Little rights refer to A. The underground water table. B. Water within a defined flowing channel. C. Non-flowing water. D. The right of ingress and egress, answer C. Non-flowing water, lakes or seas. 10. To get to his home, A has an easement of ingress and egress over the land of B. As to the easement, A has a servient tenement. B. The easement is in gross. C. The easement is an appurtenance to B. D. A has a dominant tenement, answer D. A has a dominant tenement. 11. Acquired by accession most likely refers to A. A prescriptive easement. B. Accretion. C. An encroachment. D. An easement in gross, answer B. Accretion. Join 2. 12. A boundary stream suddenly changed course, resulting in removal of land from one owner to another. This is an example of A. Accretion. B. Avulsion. C. Erosion. D. Reliction, answer B. Avulsion. 13. An owner who excavates on her property below the level of a neighbor's foundation is A. Always responsible for damages to her neighbor's structure. B. Required to give notice to the neighbor of the proposed excavation. C. Both of these. D. Neither of these, answer B. Required to give notice to the neighbor of the proposed excavation. 14. It goes with the land best describes A. A homestead right. B. A license right. C. An appurtenant easement. D. An easement in gross, answer C. An appurtenant easement. 15. A sign company that has a right to place a billboard on the land of another would most likely hold A. A license. B. An easement in gross. C. An appurtenant easement. D. A fee simple, answer B. An easement in gross, because it is a right. 16. John had all the elements of an easement by prescription for 4 years. The owner then gave permission to others for similar use of the property. What are John's rights? A. A new 5-year period would start. B. Multiple use defeats the user's rights to an easement by prescription. C. The permission granted to others defeats John's chances of obtaining an easement right. D. With 1 more year of open, notorious, and hostile of use, John can obtain an easement. Answer D. With 1 more year of open, notorious, and hostile of use, John can obtain an easement. Can be multiple easement holders and licenses. 17. Owners may not protect themselves against users obtaining prescriptive easements by A. Recording a permissible use statement. B. Posting right to pass by permission and subject to control of owner. C. Ordering wrongful users to cease their trespass. D. Doing any of these, answer C. Ordering wrongful users to cease their trespass must actually stop the use. 18. A grant of mineral rights made no mention of an easement to enter the property. What are the rights of the mineral rights holder? A. The holder must make a subterranean entrance from outside the property. B. The holder has no right of entrance. C. The holder has an implied easement to enter and mine. D. The holder can obtain an easement by necessity but must pay the fee owner for all resulting damages and loss of use. Answer C. The holder has an implied easement to enter and mine. 19. A landlocked property owner would likely ask the court for a. An easement by prescription. B. An easement in gross. C. An easement by necessity. D. Adverse possession. Answer C. An easement by necessity. 20. An easement by necessity requires a. Payment for the easement right. B. Former common ownership of the dominant and servient tenements. C. Both of these. D. Neither of these. Answer B. Former common ownership of the dominant and servient tenements. 21. In the course of a sale, the seller told the buyer there was an easement to the property over other land the seller owned. The seller may not deny the easement, because of a. Prescriptive use. B. Estoppel. C. The statute of frauds. D. Necessity. Answer B. Estoppel. 22. An easement by grant will be lost through a. Nonus. B. Foreclosure of a prior lien. C. Merger of the dominant and servient estates. D. Both B and C. Answer D. Both B and C. 23. Which would not terminate an easement created by grant. A. The destruction of the servient tenement. B. A merger. C. Nonus. D. A quitclaim deed to the encumbered property from the dominant tenement to the servient tenement. Answer not terminate. C. Nonus. 24. For 6 years, Alfred, with Smith's permission, used a shortcut over Smith's land to get to his home. Alfred likely now has a. An easement by necessity. B. An easement in gross. C. An easement by prescription. D. A license. Answer D. A license, because permissive use. 25. What is not true regarding a license? A. It goes with the land. B. It is an interest in real estate. C. It can be inherited. D. None of these are true. Answer D. None of these are true. It is a revocable personal privilege.